Is there a motion we go back into session, please?
Second.
All in favor, please say aye.
Aye.
Because of, scheduling here, I'm going to skip ahead for a second and go to the committee business item C, second reading of the public hearing. Ask Jim or Amy Albee to come forward with that.
Sheila, can you change it to the computer?
Thank you.
Thank you, Judge and Magistrates. Good afternoon. This is a public hearing related to ordinance established to make some changes to the zoning ordinance. It's KOC 18-920-447. And I'm going to give you just a quick history of why we're here, and then ask that we bring up Amy and Michael Williams to go through parts of the ordinance. As you know, we have a study review committee that's a subcommittee of the Planning Commission, and there are quite a few members of the Planning Commission. There are 6 that are on the study review committee. Kevin Jeffries is not only the chair of the Planning Commission, he's chair of this study review committee. And then we have regular participants from non-voting members that are related to our Joint Planning Commission. So Mayor Dybel comes regularly to meetings from Crestwood, Mayor Rogers from Pewee Valley, and Mayor Davenport is usually represented by Mary Ann Smith. We've had a number of study review committee meetings. You can see that starting back in October of 2016 related to this particular group of subjects, all the way up to February of this year. And this is a list of all the community participants that have been fairly regular or commented at our meetings. The planning documents that we used back in February 2014, we updated the Oldham County Comprehensive Plan. We redid that comprehensive plan completely. I call it a major overhaul. Now we're into the comprehensive zoning ordinance. That's the regulations that govern land development in Oldham County, and also one section of the subdivision regulations. And these are part of the current study review committee recommendations. The timeline that we're dealing with is that the study review committee met up until February 22nd of this year. Then on the 27th, we went to the Planning Commission. We did have a public meeting on a Saturday. That was on February 10th. There were about 35 people that came to that meeting. So the Planning Commission has recommended now to the legislative bodies the particulars of the zoning ordinance. The topics in the zoning ordinance are Division 270-050 school capacity standards, Division 300 landscape regulations. We have a new section that we haven't given a division number yet, is short-term rental property. And then we're recommending a few height regulation changes. And then also in the subdivision regulations, Article number 3, subdivision consideration process. So the first thing we want to talk about in particular is school capacity ordinance standards. And what I'd like to do is go through the subject matter, have questions, have public comment, and then if you're all in agreement, either consider approval or changing to the ordinances. And we'll take it by each topic. I think it'll be easier that way, Judge, if you're okay with that.
I am.
Okay.
All right.
I'm going to have Amy come up and talk about the school capacity ordinance.
Hi, good afternoon. Amy Alley with Oldham Planning and Development Services. I have Michael Williams here. He is the Director of People Personnel at the Oldham County Board of Education. So I'm going to go through this kind of quick here. Division 270-050 speaks of school capacity standards. Part 2, it says, as any part of the consideration of any request for to rezone property. Previously, the way that this read is that properties that were only going to be rezoned were subject to school capacity standards. So if a property was already zoned R2 or a farm was zoned ag and they were all going to be 1-acre lots, it didn't require a zoning change. The way that this previously read is that they were not subject to school capacity. So we have deleted part of where it says of any request for rezone property for residential purposes that creates more than 2 housing units per year. It just says now as part of any consideration to subdivide land. The next page here under part 3 was just some grammatical changes where previously it just said Oldham County School board. So we now have that change where it says Oldham County Board of Education. So those are just some grammatical changes there in part 3. Part 4, again, at the beginning where it talks about students generated, defined, applied. Again, it just says Oldham County Board of Education. The form and method of arriving at the figures and data informing relating to students generated per dwelling shall be reviewed annually. We've had this process in place with the Planning Commission where Mr. Williams will come in and go over the analysis of how many students the increase was from the previous school year and that year to date, and then he equates a per student number per building permit, and that's how they do part of their capacity planning. So we have on here the form and method of arriving at the figures, data, and other information relating to students generated per dwelling shall be annually reviewed for accuracy and relevancy at a planning commission meeting by the end of each calendar year. Excuse me. And then again, just the next sentence there just is another grammatical change that says Oldham County Board of Education. And then the next item says that the commission may, based upon the review and its results, decide to alter, amend, or substitute the average students generated per dwelling unit to be considered, but must have a statistical basis upon which to do so. We've never had that in the instance before, so it would just come back to the Planning Commission if there was any deviation from those numbers. This is where you'll see the most significant change and information is relating to mitigation. Previously, there were 4 items that outlined mitigation. The one that was most frequently used was item D, and it just said phasing, period. There was no definition or outline of what part of mitigation was considered for phasing. So again, we worked with the study review committee members, the community, and with the Board of Education staff. So now phasing says the Oldham County Board of Education has adopted the campus capacity worksheet, which is a chart that averages the combined school capacity of the serving campus being the elementary, middle, and high school serving the proposed development, and applies a multiplier to calculate the number of building permits allowed per calendar year for the proposed development. This is very similar to the one where we get, that I just previously spoke of, that where Michael comes up with the number of students per building permit. It's the same language that there. It says the form and method of arriving at the figures, data, and other information relating to the campus capacity worksheet shall be annually reviewed for accuracy, relevancy at a planning commission meeting by the end of each calendar year. And again, it goes through the same language there. The 3 items listed below are 3 of the key factors. It says the number of building permits allowed are cumulative on an annual basis per calendar year. The allowable number of building permits will not be reduced as established by the binding element. And the applicant can petition the commission for revision of a binding element if additional capacity becomes available. That third one there, an instance would be if a development came through and the capacity was figured at 120%, and that developer was only getting 15 building permits per year. And 2 years later, the Board of Education builds a new school, and children are redistricted, and so the capacity at the serving campus changes, and they went from being at 120% capacity to 102%, and that changed the allowable building permits allowed per calendar year from 15 to say 25. The applicant can petition the Planning Commission to revise that binding element with those new figures to increase the number of building permits that they can will be allowed per year. But that would be incumbent on the developer to come to the Planning Commission with the proper documentation from the Board of Education showing those numbers have been revised. This is the campus capacity worksheet. You'll see here on the left-hand side, this is the figures for single-family home developments. I have circled and crossed out the portion of the campus capacity for multifamily development. We had been recent discussions with some people regarding multifamily development and realized that this is somewhat flawed because the way the language reads now is if it's single-family, you get the building permits at the time of record plat. Multifamily do not go to record plat. Like an apartment complex doesn't go to record plat, and also they do not get building permits for each individual apartment unit. They get it per building. So if someone, if we use these numbers and say that the capacity was at 110%, that means they could get 18 building permits per year. Well, the whole complex could be 8 units and have 200 apartments. So it doesn't work. So we're asking fiscal court today to just not include this campus capacity worksheet for multifamily development. We will take this information back. We'll do some research and work again through our study review committee and Mr. Williams with the Board of Education to come up with a new scenario and campus capacity worksheet for multifamily. So this is an example of how this would work. And 199 lot subdivision in Locust Grove Alignment 1, and Mr. Williams, all of the school alignments based off of what elementary, middle, and high school are all set, and this is the information that we get from them. So an example of this would be that the current capacity for Locust Grove Alignment 1 is 110.98%. So if we went to the chart here, under the campus capacity single-family home development at 111%, that means the developer would get 22 building permits per calendar year beginning at the time of record plat. Not at the time of approval at Planning Commission. It's the time at the time they go to record plat. So at the time of record plat, this is an example, if the record plat was recorded in October of 2018, the developer would receive the following building permits per calendar year. So this shows how that development would be phased out at 22 building permits per year. One of the other caveats is, in the proposed regulation says that permits will be cumulative per calendar year as well. So in the same example, if the developer came in October of 2018, they were allotted 22 permits. They only applied for and were granted 10 permits in 2018. That would give them 12 permits to carry over into the next year. So in 2019, they would get their normal allotment of 22 plus their 12 carryover. So in 2019, they would be allowed to permit and grant 34 building permits through our department. I'm going to let Michael Williams come up and explain how this information is derived. I went through that very fast, but Michael will explain how the campus capacities are figured.
Okay. So that you all sort of have an understanding. Each year, the school district charges me with the responsibility of calculating how many students we're going to have for the coming year. I start that basically at the end of the first month of school, so I start to look in September how many kids we're going to have for the next year. Dr. Arvin, who many of you know, actually started all that process, and I sort of inherited it. But on average, we run in the last 5 years, we've been about 98.6% accurate, projecting district-wide the number of students we're going to have. So when we started to look at this process and discuss this process with Amy and Jim and their staff and our staff, what we looked at is, okay, so how many kids are there in each campus? We had to establish that, and we do that annually, as Amy said. But we also looked at, as the growth comes, and we're not here to say we don't want any more growth in Oldham County. We just remember and have lived through, and it was when I started in the district, when the district was growing by 500 plus students a year. That's a school a year for us in some cases. We can't fiscally handle that. We need, and we have been very blessed by the district or the county adopting this to help us sort of manage that growth. So when we looked at all of this, we looked at what point, as we started this, where would we be able to handle the most growth? Well, at 95% capacity on that campus, we could handle that growth really without any issue. We see some of that just from normal attrition. But as it grows down the line, you see that multiplier starts to slow that number down. And where we looked at that and how we came at that was, as those capacities grow in those buildings, how does that affect the learning environment? And so you see how the numbers change. But you also see that as we talked through this with the study review committee, we have a starting point of 35. We have a bottom point that no development would be granted less than 15 building permits a year. So we're not shutting off building in the county at all. Now it slows it, you obviously see it slows it down significantly. But again, that just gives us a chance to catch up, whether that's being redistricting or in the process of building a new school. New school for us is basically a 3-year process. It's a year of planning and 2 years to put it in the ground. So it gives us that chance to catch up. And Judge, I will be more than happy to answer any other questions. That's it in a nutshell. Like I said, we run about 90, in the 98, 90, high 99% accuracy over the last several years.
Magistrate Greenwell.
Thank you. I'm glad you used the example of, shut that off. Okay. East Oldham, Locust Grove, and Oldham County High School. Is 111% an accurate figure right now?
Yes, sir.
At what point do you consider that to be excessive?
For which school? I mean,
for the-
campus-wide, yes. But you also have to understand something. Elementary schools are a different animal for us because the students are basically in one classroom for the predominance of the day, other than going to art, music, and PE. Where at middle school and high school, and more so at high school, and I'll explain why in a second, when students change classes, that gives us an opportunity to, if that teacher's on planning that period, still use that classroom where another teacher comes in and uses that empty classroom. So yes, our capacities may look high, but at the middle schools and high schools, it's easier for us to manage that through that process. If you went to Oldham County High School right now, and they're not the highest school, South Oldham High School is actually the highest, and we're in the process of what we call a BG1, which is what we have to do through KDE to get a building modification in essence. But if you looked at Oldham County High School right now, yes, they're at, Amy, can you go back to that last one? There. So if you looked at Oldham County High School right now, they're at 109.83% of capacity. But there are still empty classrooms during the day and during certain periods of the day in that building. So
Could they go to 125 and be okay?
easily.
Okay.
When, and I'm going way back, but when South High opened, Oldham County High School was built, had approximately over 3,000 students in it. So that when, and looking at, everybody keeps saying, well, when is the next high school coming? It's going to be a while because you have to have enough students to make it a comprehensive building. Plus, you're talking the expense of the last high school that was built that I'm aware of was $92 million. You know, the district does not have that kind of fund, that bonding capacity at this point, because you're talking the building, all the athletic fields, all of that come along with a comprehensive high school.
It'd be 150 million now.
Probably. That was 4 years ago in northern Kentucky somewhere.
Oh,
I can't
you're-
remember which
okay.
school it was.
I meant North Oldham is what
Oh, yeah, no, North Oldham, well, because North Oldham was a modification of a building, and then we built the addition onto it. South High is also, the state has recommended for us an addition of 18 classrooms to South High. The process is trying to figure out how to put 18 additional classrooms in South Oldham High School.
Thank you.
You're welcome.
Magistrate Dye.
This, what you have right up here, what if you had a subdivision and opened up across the street? Same number of lots and everything. How does that skew this number here?
Well, so as the process goes through this, and let's say the first subdivision, this gets adopted. The first subdivision that comes and gets approval, what's going to happen is I have a running chart of all the approved subdivisions, how many lots there are, and using our calculation of how many students we get per building permit, I start to basically keep a running total of, okay, I can expect another 48 kids out of this subdivision. Okay, I can't guarantee, oh, they're all going to be elementary school, they're going to be all middle school. I can't guarantee that one. But what I keep is that running total. And so what happens is subdivision 2 comes along. Well, now for subdivision 2, I'm going to take that capacity and I'm going to say, okay, here's what's actually enrolled in those 3 buildings. plus I know this is coming, so I'm going to stick it on the bottom. So it may actually take that next subdivision to 113% of capacity. So we keep a running total so that we know, and then it's phased out as they start, as they're accounted for in the buildings.
And you get to the point where there's too many subdivisions, you're gonna say, don't have the capacity for that subdivision?
We really can't because we've agreed to the minimum of 15 building permits. And I will also say this, we're not going to allow the district, we would reach the point of, we look far enough ahead that we're going to go, okay, it's time to build the next building. We're already in the process of starting what we're not calling it redistricting, we're actually calling it rebalancing of the elementary schools to bring them in line, because the state has basically told us before we can even apply for the next elementary school to be built, all our schools have to be at a minimum of 85% capacity. They can be over that, but they have to be at a minimum of 85% capacity. We don't have all our schools that way right now. We've got some that are skewed downward and some that are skewed upward to that.
In industry, they call that right sizing, the balancing.
Magistrate Logston.
Michael, thank you for coming up here today. I'm going to vote for this because I've always said that unless there's just something skewed about something, that I will always do what planning and zoning, because they spent 2 years working on this. They're the experts. They've taken all the testimonies to get this thing done. But I'm a little afraid of this school capacity, because basically we're putting our growth in Oldham County into the Oldham County School District's Board of Education. I believe in smart growth, and I think that's what y'all are trying to do here. But basically, this is just my opinion, because unless you're growing, you're dying. And that's the only way. We have 2 ways to get taxes, 3 ways. Either raise property taxes, insurance premium tax. These are the only ways we raise. So if we're not growing, we're dying. I'm a little worried about this because it puts all of our eggs into the Board of Education's basket, that, whatever y'all say, because I know that, and correct me if I'm wrong, but 35% of the taxes go to the school and then 35% goes to a building fund somewhere. Is that, am I wrong on that?
I'm not the expert. I'm not in the finance office, so I know we get a certain percentage, but in my office, I don't know where it goes.
Basically, you're saying that when y'all build a school, you're going to decide when to build a school, and if not, then the builders can't keep building subdivision, except for the 15 that's allowed it. So and I'm not trying to jump on you or anything. It just scares me a little bit approving this because of that, and it's just my own personal preference. But I appreciate you coming up here and talking to us about it. And again, I'm going to do what planning and zoning asked us to do, because they sat on this thing for years and went through all the study review committees, and this is what they asked us to do. So, but I am a little concerned on this one.
Magistrate Logsdon, I'll answer that this way, and this is from the guidance of our attorney. We are a commodity just like anything else. And the Planning Commission can always go, well, Michael, we understand you're at X capacity, but we're going to approve this anyway. So it's not us saying no. Ultimately, it would be the Planning Commission. They can look at our data, but they can always take that data and say, well, we're still going to approve this anyway.
You know how much feedback we get when anybody wants to put a subdivision in Oldham County, and the pressure will be on with the study review as being a major factor of approving that subdivision.
Right.
And again, I'm going to vote for it because planning zoning put it up here in front of us, but it is a concern of mine. So I'm just giving you my concern.
And I understand that, and I appreciate that. I'll also tell you, Magistrate Logsdon, that we're not going to let, as a district, because if we start to let that occur like we were before and putting kids in I don't want to call it a closet, but having kids on the stage and all of that, that affects the learning in our buildings. And
No, I agree
I've had the
with that.
superintendent basically say that it's not going to happen.
And I believe in smart growth. So I don't have, my only problem is I feel like we're just giving all the control to the Louisville school, or to the Oldham County School Board. So, and that's just my opinion.
Well, let me jump in here, because Michael's trying to defend what his position is, and his isn't the, he's the pupil personnel actually your truant officer, a bunch of other things. We had a discussion about this at the study review committee level, and one of the things that we found is that there is a policy that the Board of Education has. It's an old policy, but it's still intact, that says that if the capacity gets to the point, and I can't quote it exactly, they are required to redistrict, build a new school. There's a number of steps. So they have their own internal policy. If it ever gets to the point that in fact the Board of Education is not responding to growth, then we can come back here and you all can change this ordinance. I mean, that's really the catch-all in this. If you feel that it becomes incumbent upon local government to change that ordinance and do something different. In the past, we've had capacity planning, and it goes to all of our infrastructure. So we really don't have any utility, including the schools, that are lagging behind in their ability to keep up with that capacity. So our recommendation is based on a lot of discussions, and a lot of those are with the building industry itself. And they're the ones that are in actually support. They reduced the number from 40 building permits to 35. They were comfortable with it. They were the ones that recommended a bottom, so there's a minimum of 15 building permits. So everybody in all the discussions that we've had in the study review committee has confidence that working together with the Board of Education, this is going to work well.
I agree with that, and that's why I will vote for this, because y'all recommended
Okay.
it. But I still have concerns about it.
Got it.
Don't vote for it then.
I got to. I've set the policy.
I'd like to ask Michael here, or Jim, this doesn't really address in the builders who do, like I'd say, fill-in lots. I need 2 building permits over here on this street and a third over on that street and so forth. This is just unit builders, correct?
Well, it's new development, first of all, so this would apply to any development that's coming through the process after this is adopted.
Okay, well, I mean,
If
but
there's
just getting a building permit for a lot on the street is not a development.
That's correct. Well, if you do a minor plat, let's say I have 5 acres and I divide it in half and I sell you one, you are not subject to this ordinance.
Okay, my next question, this infers here that if it doesn't work, there can be future revisions made, okay? Who is in charge of those, deciding what the parameters of those revisions are?
Well, ultimately, the legislative bodies are the ones who are adopting this because it's an ordinance. So you could direct us to go back to the study review committee and consider changes and then bring them forward to the legislative bodies.
What is the impact of the, let's say, down here, the first bullet point on the bottom of a page with no number here, number of building permits allowed are cumulative on an annual basis.
Right.
What are the ramifications of cumulative versus non-cumulative?
Well, we discussed this in the study review committee, and given that we have this multiplier that actually reduces the permitting from 35 total down to 15 as a minimum, this allowed for a builder who's maybe doing marketing or a brand new subdivision that doesn't yet quite have any momentum. The cumulative allows those to be carried over to the following years so that ultimately they can won't have to slow down their marketing efforts or their building or sales.
Pull the trigger when the time is right.
Correct.
I mean, is that satisfactory, I guess, to you guys? Okay. Anybody else have anything? I should, Eldridge?
Yes, sir. I was there on the Saturday meeting. I think I have a pretty good understanding of this, and I'm glad to see you not on death's door anymore.
Yes.
The one thing I didn't follow here today was, I don't remember on that Saturday, y'all talking about alignment 1, alignment whatever. What is that alignment term?
Can you put on the overhead?
Okay. All right, so when I talk alignment, I start with each elementary school. And you see Buckner Elementary School only has one alignment because it's Buckner, Oldham Middle, Oldham High. But then you go to Camden and you notice that Camden has 2 alignments. Okay, Camden has Camden East Middle, South High, and then Camden South Middle, South High. We're talking alignments, that's what I'm talking about. And when we look at a new subdivision, I'm going to go, okay, what elementary school, what middle school, what high school? And then I look at those alignments and say, how do those numbers lay out so that I know where we're going?
So all of the kids in one subdivision would have the same alignment, I assume?
Correct.
Thank you
Right,
very
and-
much.
And Michael, for clarification, the alignment is based on the location physically in the county.
Yes.
So they would go from Camden, depending on where their subdivision is, to either East Oldham or South Oldham for the middle school.
Magistrate Hounds.
I saw a statistic somewhere recently about the birth rate change. How does that figure into the equation? Because, you know, we're making some assumptions that, I mean,
We're making big assumptions.
Okay.
And so that you all understand, in projections, we look at a multitude of factors. Birth rate is one, building permits is another, but also what we call a rate of survival. How many students do we have that survive from kindergarten to first grade to second grade, all the way up the line? And if you look at our numbers, because we still are a growth district, we have slowed down considerably, but we still are a growth district, we're 100+% all the way up until roughly ninth grade. From ninth grade to 10th grade, because of you don't have enough credits to be a sophomore, or you don't have enough credits to be a junior,
Right.
that number skews downward. Only slightly, but it still skews downward. So all of that plays into, when we look at projections, how many kids we're going to have for the next year. So birth rate does play into that. And yes, birth rate is down, but we have seen small spikes. So, you know, we look at that each year. And that's some of the data that I actually get from the health department, and it's calculated into this whole process. And what we do with that is, based on the number of kindergartners we have on the 3-year average, the
Carry that
5-year
forward.
average, how many of that birth rate carries forward for us? And we actually usually have more kindergartners than we had live births in the county.
makes sense because you still got transit people coming into the
Correct.
county. Okay.
All right, thank you, Michael. This is a public hearing. I think we're going to take a vote on this section of the, just a second here, but I want to ask if there's anybody here who would like to speak in relation to this, either for or against. Okay, we have one person to speak, and I know,
Jeremy
go ahead, state your name and address.
Jeremy Esposito, 504 Woodlake Drive, LaGrange, Kentucky.
Jeremy, do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir. I sat on SRC for the past 2 years. Past 12 months we've been working on this. I do represent the Building Industry Association. I'm a builder, not a developer. I could care less if there's another development put in Oldham County, to be quite honest. Half of ours come from remodels, which I'm good with. However, we do approve and want this to go forward just for the simple fact that it's responsible growth. There's a lot of work and thought put into it, especially from a Board of Education standpoint. So the building industry as a whole thinks this is a good idea. It's responsible. It doesn't allow us to go too low, but it also doesn't allow someone to come in and develop 100 at a time in an area that doesn't or couldn't support it. So I've got children in the school systems, and I want them to still get a good education. So that's my take on it. Thank you, Judge.
All right, thank you. Anyone else who would like to speak? All right, please state your name and address again.
Larry Kaiser, 3000 Maple Leaf Drive.
This is a public hearing. Do you swear to tell the truth, the whole truth, nothing but the truth? So help you God.
Yes, I do. There's mainly two questions. I know with recent legislature, charter schools are now allowed in Kentucky, presumably in Oldham County. I'm personally against them, but if they come into here, how does that change that? And then the second question is, if, let's say in year 2 of your example, I think with Locust Grove, where they get the 22 building permits a year, let's say a second subdivision was going to be built. Are they restricted, or are they then limited to the minimum of 15 that you keep referring to?
I'll take the first question. As far as charter schools go, I think the Board of Education, we would view it the same way, that some students that live in Oldham County actually go to private schools, whether it's a Catholic school in the county or out of the county or a high school. And so charter schools would be looked at the same way. The growth projections that the Board of Education, Michael, puts together are all predictive, if you will, and I think responsive to what might be charter schools. The question about the number of building permits, as Michael explained, any school, any alignment, if development comes in, their numbers go into the projected school population. The next one comes in, it increases maybe the capacity. So his example was at Locust Grove, it's 111%, it might raise it to 113%. They would then be evaluated on that new percentage based on the growth population that's put in from the first one, and on and on. If there was a second, a third, a fourth, a fifth, they would all be looking at it from additional capacity and whether or not they were able to get the same amount of permits or even less. But I'm not sure if that answers your question.
All right, thank you. Anyone else? All right, I'm going to close this portion of the public hearing and go to see, is there a motion now that we adopt the school capacity ordinance?
So moved.
Second.
Second.
Any discussion on it? Yes, sir.
Ask for anybody to speak against.
Well, I asked if anybody wants to speak, period. And,
You were inferring against.
huh?
You were inferring
No,
against.
no, I just said anybody would like to speak in relation to the ordinance. So
Okay.
you could be for or against it. We just had seek clarifying explanations.
Wanted to be sure.
All right, Magistrate Likens?
Yes, when she was giving her presentation, she crossed out the second half of that campus capacity worksheet. So we need to make the motion with that
Removal.
said,
Yes.
All right,
that second half Xed out.
all right,
Yeah, thank you for that clarification, right.
that.
You-
all right.
And let me just say,
Okay.
As presented.
As presented, right.
and let me just say, this is the only part that references multifamily. There's nothing else in any other part, so that's why we have to go back and actually add, and we'll be back in front of it at some point.
Okay, we have on the floor here, Nora, a motion in the second to approve the school capacity standards portion of the ordinance as presented.
If that covers it.
Any further discussion? Hearing none, all in favor, please say aye.
Aye.
Opposed? Motion carries.
Thank you, Judge. After we go through all of these, you'll be looking at considering the entire ordinance, but I'm glad that you're looking at each one of these separately. So the next section is Division 300. That's the landscape regulations. There is a lot of information in the landscape regulations, and for the sake of time, I'm going to go through only a couple of the highlights. In particular, a few of the things that we've added. Item number 3 on this page is that no additional items or placement of or removal of items is allowed in the right-of-way without an encroachment permit. The encroachment permit is a process in the county engineer's office, so anything in the right-of-way, whether it's a utility, a tree, a mailbox, whatever it might be, has to get an encroachment permit, and the county engineer can either approve or deny that encroachment. The other clarifying point is that single-family residential lots are actually exempt. We've had questions years ago about, well, how come one house doesn't have to have a landscape plan? Well, this is for an entire development, not for each individual house. One of the things that we did in the current regulations, some of the requirements are hard to follow in text. So actually, Brooke Veman is the one that put this together. There are a number of charts that make it easier to follow the requirements. So in this particular case, this chart is in relation to the number of trees required or shrubs, and then the number of species. So one of the things that we don't want to do is keep planting the same species and then some kind of bug or blight gets them and they all end up dying. So we're requiring that there be a mix of species. This chart, another example, making it easier to understand where planting requirements are in each of the land use categories. So you'll see on the left-hand side, the land use, the minimum width of a landscape buffer area is clearly spelled out in the chart, and then the screening height and the minimum number of trees for that landscape buffer area. And again, I'm really just jumping through these. There's a lot more pages in the landscape regulations. One of the key pieces that we added in the code enforcement is about code enforcement and fines. So we have a section with 4 points in the requirements regarding code enforcement. After a landscape plan has been installed, they're required to maintain it. Yesterday, we went through a couple of the points in the landscape regulations, and we do actually have 6 minor changes. These are all really, there's a clarification, 4 changes, and 1 minor addition, and I'm going to go over those with you briefly. In this case, when we talk about bonds, it says that the banking institution should have offices in Oldham County. Well, that would limit it to only a few. So it's really, in all of our other bond requirements, it's the state of Kentucky, not Oldham County. Another item is in section 300.040. We actually are going to strike a few things. Item number 3, we are striking a sentence, ultimate determination of said potential interference and identification of remedial specification of planting vests in the planning staff. That's really not a necessary statement, and so we're going to strike that. Item number 13, when we talk about earthen mounds or berms, specifically, we want to make sure that they aren't detention or retention basins and they're not holding back water.
That was passed out because we're looking at
Oh, I'm sorry. Right. Amy passed out these clarifications, so you have them in front of you rather than in what was sent out by Sheila. These are the few items that we've reprinted, and that would include this. Item number 14, where we talk about site triangles. We've taken out an illustration and the following statement that said the site triangle shall be measured from edge of pavement to edge of pavement. That's in relation to keeping a clear zone so that the site distance that you have up and down the road is maintained. If you start putting obstacles in the site triangle, you won't be able to maintain the site distance. In the general standards regarding landscape buffer areas, we're going to just put a period after all landscaped islands shall be designed to apply sustainable techniques, and allowing for the flow of access and stormwater and landscape areas with curbs should be protected by tire stops. Again, that's not a necessary part of the regulation, and that will actually be covered in the construction plans. And then under item D in that same section, general requirements, we had a sentence that said areas shall be placed at the edge of pavement or back of curb if present, and that was a little bit confusing, so we're striking that out. So those, again, were a few minor changes that we made in passing this forward to you for your consideration. And I don't think it constitutes any substantial changes to the balance of the landscape regulations. So I know
Right, is there anyone here that would like to speak for or against the landscape regulations as presented? Seeing no one, we'll close this portion of the public hearing and go on to the, is there a motion that we adopt the new landscape regulations?
So moved.
Second.
All right, moved and seconded. Is there any discussion on this? Magistrate Likens?
Is this landscape regulations all new? Because the others, you had put red lines where they changed the language, but is this a new regulation or an existing?
No, a lot of it is existing, and all the red line and strike-throughs were done at the study review committee level and the planning commission level, and for us to show you all of those, it would be nearly impossible to follow. So this would be taking everything that's currently in Division 300 and substituting the document you have in front of you. So it really is kind of a throw the old one out, put the new one in. But a lot of the information is similar.
We did have first reading on that. Yeah. Anyone else? Magistrate Dye?
We had some discussion over this, Jim. some places it's a little confusing for me. On the required number of trees and shrubs, what exactly type of development does that cover?
First of all, it's any new development, and principally, it does not cover really single-family residential development. We don't have the landscape buffer requirements. It's when you have a development next to a different intensity land use. So if you were putting a commercial development near a residential, it would apply. So I would term it as kind of single-site developments, if you will, not subdivisions. Although things like putting nothing in the right-of-way applies to subdivisions as well.
Well, that's the other question I had. It says very plainly, you're not to put anything in the right of way unless it's in one of those type of containers that the roots can't get out of, a non-permeable surface thing.
That's again, if it's approved by an encroachment permit.
Right. But these new subdivisions, when they put trees between the sidewalk and the curb, or the shoulder, or if there's no sidewalks, like on a cul-de-sac, between the edge of the right-of-way to the edge of the right-of-way, is that in or out?
If it's in the right-of-way, it would need an encroachment permit. And so that would be subject to an application to the county engineer's office for a road encroachment permit.
So when the developer comes in and builds a new subdivision, they're gonna line the main drag with 40 trees. They gotta get 40 encroachment permits, correct?
Well, it could be considered all under one encroachment permit.
Okay?
They would have to come in with a landscape plan to do that.
Okay.
And
So you all would
depending,
approve the encroachment permit, you would approve the tree that you're gonna plant, or trees that they're gonna plant?
Part of the application.
Well, yeah, but they're gonna have to sign off on the permit, right?
right, we work, we would review the planting material and, based on the landscape regulations, so the varieties, size, all that, in conjunction with the county engineer's office, looking at it from an encroachment permit perspective. And obviously, you know, whether there are utilities there, whether the encroachment would cause any site distance issues, whether there'd be branches over, we'd look at the plant, the way the trees grew, the location, whether it was too close to the roadway or not.
And next, last, two more questions. Who maintains this tree that's got the encroachment permit that's been approved?
Well, one of the things that we've talked about is that in getting that encroachment permit, that it would have to be clear that let's just say it was a brand-new subdivision and they wanted to plant street trees and it was reasonable to plant those trees, they would have to have a deed restriction, a statement in their deed restrictions that said that the developer or the HOA would have to maintain those trees in that public right-of-way.
What if there's no HOA?
Well, then we'll sue each individual property owner, I
All right,
suppose.
then the last question. If you take a tree out, the tree dies, do they have to put it back? The HOA and/or the individual property owner?
Well, it doesn't say that anywhere in the regulations. Again, these would be, in terms of trees in the right-of-way, that would be up to either the developer or the HOA to maintain, remove, or replace.
Okay, the reason why I asked these is Metro did something like this, and I have a subdivision that's half in, half out. And so I just want to make sure how you all are different and alike of what Metro's doing.
Right,
Okay, thank you.
okay.
Anyone else have any questions on this particular section? All right, do we want to take a vote on this section? All right, is there a motion to approve? I already have a motion and a second. All in favor, please say aye.
Aye.
Opposed? So moved. All right, does that include the Louisville Metro tree list?
Yes, part of our regulation, Paul Capiello, who is the director of Udell Gardens, worked with Louisville Metro to establish both a preferred plant list and a prohibited plant list, and they've allowed us to just adopt it. They've been checked for availability and the ability of the plants to survive in this region, so it's a really comprehensive and good list.
Did we change that to say Oldham County approved plant list?
Well, once we approve it, we will, sure. At this point, it's not an Oldham County approved, but yes, good point.
And that might be something that we want to publish on the website, that approved plant list, because I'm dealing with a situation now where something was planted, and the removal of it is gonna be, the species is taking over another species kind of a thing, and it would, I think maybe if we put that list out there, I'm sure our nursery folks know, but the general public that's going someplace else may not. And then, Judge, I was gonna ask the question, do the Home Depots and the Lowe's, do they know about this list, and are they selling products that are approved in that list? Do you know?
I don't know that. I know some of the nurseries carry that, and most of them, you know, the ones that are most important are the ones that would be prohibited.
Right.
And again, the Lowe's and Home Depot is not where a developer of a commercial property is gonna
Yeah.
go to buy their plants. That's where the homeowner is gonna go. And again, these regulations don't apply to single family. So
Okay.
hopefully they look at our list and buy the plants that are on it, because they, again, are probably more
That's what
prone
I'm
to
saying.
survive.
But
in
the
this
homeowner
region.
replacing something, they may use that list, is what I'm thinking.
Be a good thing. Yes.
All right, next item, who's gonna present that, Amy?
All right, our next item is short-term rental properties. This is a totally new regulation. This is not addressed anywhere in our zoning regulations or our subdivision regulations. So what is a short-term rental? We had to add definitions into the regulations. A short-term rental property is a residential dwelling unit that is used and or advertised for rent for transient occupancy by guests. Dwelling units rented to the same occupant for more than 30 continuous days. Bed and breakfast establishments, boarding houses, hotels, motels shall not be considered a short-term rental. So key is that it's rented to the same occupant for more than 30 continuous days. These are some more definitions. I won't read through all of these. We have to add that definition of what a boarding house is, commercial establishment, hotel, and transient. I will review transient because that is used numerous times throughout the document. A transient is any person who exercises occupancy or is entitled to occupancy of any rooms, lodging, or accommodations for a period less than 30 continuous days. There are two types of short-term rental properties that we are proposing. One is owner-occupied, which means the owner of the property permanently resides in the short-term rental or in the principal residential unit, which is the short-term rental, is associated on the same lot. So owner-occupied means that you either live in the house or if you have an accessory dwelling unit, but you do live on the property in which the short-term rental is located. Not owner-occupied is owner of the property does not permanently reside in the short-term rental or in the principal residential unit which the short-term rental property is associated with on the same lot. So obviously, not owner-occupied means that your primary residence is not on the same piece of property where you wish to do your short-term rental at. Key individuals when we speak of short-term rental properties. Host is any person who is the owner of record of the residential real property or any person who is the leasee of the residential real property pursuant to a written agreement for the lease of such real property, who offers a dwelling unit or portion thereof for a short-term rental. Responsible party. This is a person or business residing or located within 25 miles of the short-term rental property that is responsible for addressing all maintenance and safety concerns. So we get into general provisions here. Item 1, in zoning districts in which residential uses are a permitted use, including legal non-conforming residential uses. We had to add that language in here because previously our zoning regulations, we had tiered zoning. So an example would be Woodland Lake subdivision. That subdivision is zoned C3 commercial. Well, in tiered zoning, and previously how our zoning reg was set up, anything that was a less intense use, so anything in C2, C1, all the residentials, ag and conservation, anything that was a less intense use was considered a permitted use. So if someone in Woodland Lakes wanted to have their property as a short-term rental, they would be considered a legal non-conforming residential use, because at the time that that development was approved by the Planning Commission, they were not required to get a zoning change. And if you look in our regulations today, under C3, residential uses are not a permitted use. So basically, they would be grandfathered in under the legal non-conforming residential use. And that applies for items 1 and 2. So back to item number 1, in zoning districts in which residential uses are a permitted use, a short-term rental of the dwelling unit that is the primary residence of the property owner is permitted by the planning director with special standards set forth in this section. So if you are living on the property and you want to apply for a short-term rental property application, you can do that by right, and that is reviewed by staff. In zoning districts in which the residential uses are a permitted use and the short-term rental of the dwelling unit is not the primary residence of the property owner, you are required to obtain a conditional use permit. So if that is not your primary residence, then you would be required to apply for a conditional use permit, which would in turn be a trip to the appropriate Board of Adjustments for conditional use, which entails public notice, and then we also notify the adjoining property owners as well. And they also have to obviously apply with the standards set forth in this section. Multifamily apartments and condominiums, the applicant must either be the owner of the property or the leasee. If the applicant is the leasee, the application must be accompanied by a signed documentation of permission from the lessor or the operation of a short-term rental property. And if the short-term rental property is not the primary residence of the owner or the leasee, they again will be required to obtain a conditional use permit. In zoning districts in which residential uses are permitted, including legal non-conforming uses, short-term rental of the dwelling that is the primary residence of the property owner is permitted by the planning director. So again, if it is owner-occupied, you can do it by right with an approved application. If it is not owner-occupied, that requires a conditional use permit. No person or entity shall operate a short-term rental or advertise a residential property for the use as a short-term rental without the owner of the property first having obtained a short-term rental permit issued by planning and development in accordance with with the provisions in this section. Any advertising or description of a short-term rental on any internet website must A, prominently display the permit number for the short-term rental property unit, or B, include an image of the permit or link to an image of the permit in which the permit number is legible. So if they advertise for it, they have to include the permit number in their advertisement or a picture of it on the website. Outdoor signage which identifies the short-term rental house is prohibited, so there won't be any outward appearance that this person is renting the house for those purposes. There will be sufficient parking available for hosts and guests and shall not create a demand for parking. No food shall be prepared or served to the transient by the permit holder. So if you want to rent out one of your bedrooms as a short-term rental, you're not to serve food to that permit, or to the transient, because then that pretty much turns into a bed and breakfast at that point, which is regulated through a whole nother process. The principal renter of the short-term rental unit shall be at least 21 years of age. The maximum number of occupants permitted on a short-term rental property at any one time shall not exceed more than twice the number of sleeping rooms plus 4. The occupancy maximum shall be conspicuously posted within the short-term rental unit, and advertising for more occupants than allowed by this regulation shall be grounds for revocation of the permit. We will verify this through either the building plans if we have them on file, or through the PVA office through their tax assessment, because it usually lists number of bedrooms on there. Simultaneous rental of short-term rentals to more than one party under separate contracts shall not be allowed. So if you have a 3-bedroom home and you want to rent one bedroom to myself and another bedroom to Jim at the same time, that is not allowed. You can have one short-term rental contract per property at one time. The maximum stay for guests shall be 30 consecutive days. The name and telephone number of the local responsible party who shall reside or be located within 25 miles of the short-term rental shall be conspicuously posted within the unit. The responsible party shall answer calls 24 hours a day, 7 days a week for the duration of each short-term rental period to address problems associated with that short-term rental. A clearly marked evacuation plan is posted on the premise. The permit holder shall be responsible for maintaining proper insurance coverage on the property. The permit holder shall be responsible for collecting and remitting all applicable room, occupancy, and sales tax required by state law and Oldham County. Each short-term rental shall be in compliance with any currently applicable laws, regulations, or of the federal, state, and local governments, as they may be amended from time to time, including but not limited to laws or regulations on non-discrimination, zoning, building, safety, property maintenance, health and sanitation, fire, electrical, plumbing, mechanical, and other applicable laws. This item C goes over the process for the application. Item 1's the name, telephone number, and address, and email of the owner, host, and of a person, which would be the responsible party that lives within 25 miles, that is to address any maintenance or safety concerns. Owners applying for owner occupied must provide 2 documents giving proof of owner occupancy, and those suggested items are listed there. Item number 3 says a floor plan of the residence showing the number of bedrooms and location of smoke alarms. The floor plan can be hand sketched. Number of sleeping rooms will be checked against the tax assessor's records. Floor plan shall show details of all levels of the house and any attached structure, location of windows, doors, interior and exterior, and locations of required smoke detectors. Item number 4, a statement that the applicant has confirmed with operating the proposed short-term rental property would not violate any homeowners association agreement or bylaws, condominium agreements, covenant codes and restrictions, or any other agreement governing and limiting the use of the short-term rental property. So in the event that a subdivision has deed restrictions that says that things short-term rentals such as an Airbnb is not allowed in their subdivision, and they apply for a permit, we will cross-reference that with their deed restrictions just to confirm that they are not violating, but they'll have to sign an affidavit at the end of the application that says that they are not violating. So expiration and renewal of the permit. No person, firm, or corporation shall own or operate a short-term rental on any premise of the Oldham County unless the short-term rental has been registered annually with the Planning and Development. All permits shall expire on December 31st of each calendar year, and it's the responsibility of the owner to renew the permit. Item 1 talks about what is required, renewal of the payment of the renewal fee, a statement verified by affidavit that all the information required in the application under item C, and the rental continues to be in full compliance with all applicable laws, including payment of all applicable taxes. Item number 2, permit shall not be transferred or assigned to other individual, persons, entity, or another address, nor shall the permit authorize any person other than the person named therein to operate the short-term rental on the property. Item E is denial or revocation of the permit. Upon filing of a complaint regarding a short-term rental property permit, the code enforcement officer shall notify the permit holder in writing or by email of such complaint and follow the processes outlined in the Oldham County nuisance ordinance. The property is subject to 2 or more substantiated civil and or criminal complaints. The planning director may revoke that approval. Any denial of the revocation of the short-term rental property permit may be appealed to the appropriate Board of Adjustments as an administrative appeal. Also, if the property insurance lapses, the Oldham County Planning and Development shall have the right to revoke the permit, and once a short-term rental permit has been revoked, no new permit shall be issued to the same applicant for the same property for a period of 1 year. That was a lot, so.
All right. Any magistrates have any questions about this?
How many short-term rentals do we think we have?
If you search on Airbnb, there's probably 200 to 300 that come up. But once you look and drill down on the map, some of those are in Jefferson County. Some of them are, obviously in downtown Louisville, things of that nature. But there's not a real good way. Tourism, Kim Buckler is here. She may be able to answer a little bit more questions because she does get numerous calls about people asking her to promote. And what are the regulations if they want to do that. And so she forwards those on to us, but they are out there. They're just not being regulated and collecting the proper taxes that they should be collecting, the bed tax.
Magistrate Dye.
On the, just go straight to the denial or revocation of permit.
Yes, sir.
What is the due process on that? In other words, you catch somebody, let's say they've, somehow or another, you found out that they don't have insurance on the property. What, you just notify them and say,
Then they would need to provide us that information that shows that it is current.
and if they don't, what's the process?
And if they don't, then we will revoke their permit.
There is not like a hearing or a,
Not at that point. Only if they want to appeal the decision of us revoking their permit, then they can file an administrative appeal, and the administrative appeals go to the appropriate Board of Adjustments, either LaGrange, Pee Wee, or Oldham County.
in other words, at the same desk you get the permit, it's the same desk you get the revocation.
I'm sorry, say again?
At the same desk that you get your permit would be the same desk that you get your revocation letter?
Yes, sir.
Okay.
Would that go to the Board of Adjustments or the Code Enforcement Board?
Only if they appeal that we rescinded their permit. Only if they appealed that.
Yeah, but I mean, which board would it seem?
Amy, jump to the, if there's a clear violation and they are going to contest it, but if they are, if we have to send a code enforcement officer because we suspect there's a violation, that's where it really starts. But ultimately, they have a conditional use permit or a permit from our office. So that's typically, again, if they don't agree with the revocation, they go to the Board of Adjustments. We can take them to the Board of Adjustments to revoke that CUP as well. If they
If
don't
they
meet
got
the
a
standards.
CUP.
If they got a CUP, right.
Back here on item 16 says permit holders shall be responsible for collecting applicable room occupancy and sales taxes.
Correct.
Most of these people are going to probably come about through a outside service, not located here, that arranges. So how are we going to make sure that they, in other words, aren't they going to be paying? I don't know how this works. I've never done it, but I would assume I've been in the Uber cab. I didn't pay the driver. It's on a credit card when I ordered the thing. Doesn't this work the same way? When you call up and get a room, you pay Airbnb?
I think they take a portion of your fees that you're collecting, but Airbnb does not collect the tax on behalf of Oldham County bed tax on behalf of.
Not of Oldham County, but they have arrangements with large cities.
Other places.
But I don't know. You got to remember that Airbnb is like Kleenex. Kleenex is a brand. Facial tissue is what it is. Airbnb is a brand. It's short-term rentals. So there are other short-term rental apps. Airbnb happens to be the biggest one and most noticeable. So an arrangement with Airbnb doesn't guarantee that if they're on one of the other apps that it gets collected. It's up to the individual property owner to follow the regulations of Oldham County and submit that.
How are we going to know what they rented their room for?
It's on an honesty.
Right. You might ask Kim Buckler that.
The report.
We aren't going to be collecting that tax. It will be tourism and through our county treasurer's office.
Right, well, I mean, that's part of what's involved here is collecting that. So Kim, do you know the answers to those things? Well, come up here then. How do you expect to collect what is owed the Tourism Commission from the rentals?
What we have done as tourism for the last almost 4 years is I go through each one of those websites personally and track those properties down, because most of the time they don't even realize there is a transient tax or that they need to pay sales tax or anything. So it needed an education process anyway. The thing is, when you have what they call an intermediary, which is what Airbnb is, and VRBO and Home and Away, all those places, when a room is booked through them, they'll keep a percentage. They just passed in October last year a state statute that they collect sales tax from intermediaries now. Airbnb in particular refuses to give up their contact list. So all of those people, when they come to tourism for promotion, which is what they call us for, or they want a brown sign or whatever, what I've been doing since this whole process is sending them back to planning and zoning. Because before this process, if I had contact with them, or if I was able to track them down and let them know about all the taxes, not just this transient tax that they're supposed to be paying, then our process was in place for that. Once they started paying the transient room tax, then we started putting them in our promotions. The problem was there was nothing on the planning and zoning end. So this process here is strictly planning and zoning. This is restrictions from planning and zoning. This really has nothing to do with tourism other than a checks and balances for us. So they'll have to get the permits and all of that. You know, we don't know anything about electrical and plumbing and mechanical and all that, but once it clears planning and zoning, then we know it's a good property that we can promote, because we don't want people to come off the Airbnbs and VRBOs and those websites. We don't want them, we're not saying come off of there at all. We're saying if you're a legitimate place that is an experience for travelers, then we want to promote you too. And we do that with the transient room tax. So it's hard to get that contact information from them. Now that the state is collecting the sales tax as of October last year, that'll be easier for us to get their information. Once this passes, it's not going to be a grandfathered process, according to this document. So everybody who's collecting and paying that now will have to get a permit and all of that. Because we have 4 hotels in the county. We have 13 collecting properties. Because some of them collect the tax, but they don't want to be promoted beyond TripAdvisor or Airbnb or those places. But we get requests in tourism, for example, for people that want to stay on the river and have a river view. We have, I know, 4 in particular properties that are on the river with a river view. It's their backyard that they would love to do, to be promoted by tourism and be put in our packages and all of that in 5 states. If they pay the tax according to us, tourism, if they pay their transient room tax, then we can promote them. They're in compliance with us. But there's nothing to say they're in compliance because there was nothing in writing from planning and zoning stating obvious things. You know, we have properties that had HOAs that didn't permit it, and they were still renting their properties, or condos or apartment complexes that were written it against their paperwork, so.
Okay, so you're gonna run down and try to collect what
Well, and
the
before we
tourism-
promote them, they're gonna have to get their permit and all that, and then planning and zoning will have to pass that information on to us, that that permit has been approved, because we wouldn't know that.
You will monitor and work with
Yeah.
those people to
Yeah,
see compliance and help promote their business.
yes.
All right, thank you. Anybody else have a question here they'd like to ask? This is a public hearing as well. You know, is anybody else here to speak for or against this? Okay, I've already sworn you in once, Mr. Kaiser, so I assume you're going to continue to tell the truth.
Yes, sir. I don't understand why this came about. I'm against it. I'm not sure what problem it's attempting to solve. My understanding is, neighbors maybe don't know who's staying there. For noise issues, parking issues, in my mind, the default position should be one of freedom. That neighbor doesn't have a right to know what's going on. If we're close neighbors, I can talk to them. Well, someone different is staying in my house this week, so on and so forth. But for noise issues and parking issues, we can treat that the same whether there's an additional license or not. If there's a noise issue, call the cops. Do whatever we do now for noise complaints. Same thing with parking. If there's a street, someone can't get to their house, however you handle that, call the police. However you handle it now, do the same thing. We already pay an additional 3% tax back to Oldham County, I guess for advertising and things of that nature. I already feel that's excessive, but it's already in place.
When you
Along
say
those,
we, who do you mean by we?
me, Oldham County resident.
The only people that pay that 3% occupancy tax are the people who stay in rooms in
Right, if
range
I-
here, and that money is used to promote tourism in the county to bring other, people here for additional business.
Right, I say me because I do rent out my home or try to around Derby. So whatever Airbnb pays me, I am now required to, send you guys 3% on, in addition to the 7% I think that goes to Kentucky, 6% sales tax and 1% excise tax maybe, I'm not sure. But now 10% of it now goes. Along those lines, because I typically only do it during Derby, I now have to send a form once a month, even if I don't rent it, a tax form saying that I didn't have any rentals this month, my tax bill is zeros. So it's additional, work on the resident. But we're now set up and paying, I would now have to pay every year to renew this license that I don't still understand what problem it fixes. And so I'm against it. It's an increased cost to people who use that service and likely to the whole county. That the oversight's going to have to come from somewhere, following up different jobs that are created. Someone's going to need to pay for those. So we're already, I don't want to say penalized, but we already pay our fair share of money for that out of the different taxes. I think it's unnecessary to have additional permits that are renewed and it looks like paid for each year. So there's a cost, and then we also have to pay for the oversight of that program, who's checking for these permits and so forth. And so I don't think that's necessary. I equate that to, neighborhood kids cutting the lawns. Are we going to regulate that and make sure that they have licenses to do it, or neighbors that are dog sitting or babysitting? We don't have licenses or regulations for that. I don't think we need it for these things, and so I would encourage that we not adopt that resolution or ordinance, I guess you call it. That's all.
All right, thank you. Okay.
Just to answer that in a way, we consider this to be, the subject is really a land use. And this is really a business use of a residential property. And there are certain expectations when a person moves into a residential area that the properties next door are going to be kept up in a certain way or used in a certain way. And I want to say that these are standards that are applicable across the board. They're not restrictions, and it really levels the playing field for anybody that wants to have or wants to consider short-term rental. And, communities across the entire country have adopted similar regulations. Amy did a lot of research regarding these and pulled from a number of communities, not just big cities. So really, it's a land use issue. And because you're really using it for business purposes, that again have an impact on neighbors. And that's why, again, these standards are being proposed.
Thank you. Is there anyone else here who would like to respond or speak to the ordinance? Seeing no one, I'll close the public hearing and go back to magistrates. Magistrate Eldridge. Tice.
I've got I'm not saying I'm for or against, but as I'm trying to sit here and analyze it, if we're in a motel, hotel, and a bed and breakfast, in most cases, those facilities are rented for less than a month. I know they can rent longer than that, and I'm going to try to compare that to a residential subdivision, because if I rent my house and I rent it for somebody for a year, 6 months, whatever the deal is, it's over 30 days. I'm listening to this gentleman, and I don't know anybody on his side of the fence, so I'm kind of interested in what he said. If we're requiring is the correct word, intermediaries? Is that correct? An A, B, and B is an intermediary.
Short-term rental. Mm-hmm.
Short-term rental. Okay, that is. Are you reporting that you're going to rent it for the Derby Day this week? Is it okay for me to ask him that question, Judge?
I guess so.
Okay. If you're going to rent it for Derby Day this coming week, this year, are you right now reporting that to? Are you online where somebody's helping you rent it?
With Airbnb, yes.
You're doing that?
Yes.
So then, right up front, they're going to charge you a certain fee.
Yes.
If you're in Jefferson County, they're going to charge you that fee plus a little extra they're going to send to Jefferson County.
Yes.
Are we going to have it where they charge a fee and then charge a little extra and send it to Oldham County?
I would assume the answer is yes, but that would be up to the individual on how much they want to charge. So,
Well, I meant the extra taxes is what I'm talking about.
yeah, if they want to increase the rate to not only cover the charge from the service like Airbnb plus the local taxes, they're welcome to do that.
But if we go on the internet or whatever and tell all these people, because I don't think that's what Kim said, and what I heard a minute ago is Kim's going to have to track down our dollars. So if we went and were able to do it like Jefferson County and say that any rental you have in Oldham County, our fee is whatever the fee is, let's say 3% like the hotel. So if we say it's 3%, then what they're going to do is they're going to take their charge for renting it, and then they're going to rake off another 3%, and they're going to send it to us, is what I'm trying to say. See what I'm getting at?
If they are-
I'm a little
if
confused
they
how
are-
we're going to get everybody to pay in this thing.
Well, if they are interested in dealing with a smaller community, they're making deals with large cities.
Okay.
It's a lot easier, there's more volume. Whether that spreads to anybody in the state of Kentucky or anybody local, regional, whatever it might be, I really don't understand that. What the best way is to keep track of all of the permits that we issue and then reach out to them in the form of a letter saying, you know, now that you have your permit, tourism is requiring this, and then just keeping track of however they're going to pay for it.
And that's okay if that's not too cumbersome for our people, number one. We know that if it's a motel or bed and breakfast, we look at them and know we're there. They're identifiable. His house is not identifiable.
Right.
So if we've got to figure out a way to reach out and get that money, I'm just...
And tourism is doing that. Like Kim was saying, she is reaching out. I know that Melissa has sent out letters because the county treasurer's office collects that tax for tourism. So in the past couple of years, there have been letters sent out to identified rentals, short-term rentals.
I know we're doing that, but are we right now sending out and collecting money on these short-term rentals? In addition to the motels and the bed and breakfasts? Okay.
As I find them.
As you find them.
Yes, as they contact me or I find them, yes. Then I send that information to Melissa, then Melissa sends that information to them, and then they start collecting the tax to be promoted.
Judge?
Let's try to keep all comments on camera here so our record is clear and our viewers can understand.
That's it. I'm good. Thank you.
Okay, so, all right, the answer was that yes, the Tourism Commission currently asks people to pay the 3% when they're aware that a short-term rental is involved.
And so now with this regulation, those that want to operate under the rules would be identified by permit. That information be sent to tourism. Now we've at least identified them. You don't have to go hunt for them.
Measure Leslie.
Yes, Judge and magistrates. Some years ago, we were working with tourism on this issue, and we changed the way we actually pay tourism to make sure that her budget is a continuous budget rather than small lots of money at various times. So these taxes are not new. They've been around for many, many years. We're just having a clarification on this ordinance, so we're not really changing anything.
Magistrate Eldridge.
I think Mr. Urban made the point that we need to be cognizant of. This is not about the tax, it's not about the tourism, it's about the land use. You know, the situation that I've had in my district is where somebody was doing this and the neighbors were having problem with parking, the neighbors were having problem with noise. And they're like, we're in a subdivision here, we're all gonna be residences, and this guy's running a business. Under this guideline, they would get a permit, what they call a conditional use permit. It's very similar. I have a conditional use permit at my house for my garage because I had to prove to the neighbors before I moved in that I wasn't gonna run a business out of that garage, that I was going to have a accessory dwelling unit in there, my in-laws were gonna live in it, and it's just a process you go through. But what it is a way of ensuring to neighbors that what was once their next door neighbor Bob is not now going to be Bob's Truck Stop or Bob's Auto Repair or Bob's B&B or Bob's Strip Club or whatever. You know, we're going to keep it. We went in there with an intent for residential use, and we're going to keep it that way, or we're going to let the neighbors know up front.
And I'm okay with that. My concern was how were we going to manage it and acquire the revenue from the revenue side of it if we were going to put it in the same hat with bed and breakfast, et cetera. Okay.
Do we have any provision in here that allows the neighbors a notification that somebody intends to use their property as a short-term rental, and neighbors can object if they don't,
Yes, if
or
they-
question the use if they don't like it?
They don't live in the either primary residence or if they don't live in the primary residence, then they have to live within 25 miles, and in that case, they have to get no. I should have just let her answer that.
Non-owner occupied, so if the owner does not live on the property, it requires a conditional use permit. So the owner can live in the main house, or they can live in the mother-in-law suite or the carriage house or something on the property. If the owner does not, that is not their permanent residence, then they are required to get a conditional use permit, which in turn notifies all the adjoining property owners. It's advertised in the paper and published on our website.
All right, because contrary to what had been said here earlier, some people may be uncomfortable with a steady stream of unknown people arriving at the next house next door to you. They don't know who they are, what they're about, or whatever, and if the house is not close, that's one thing, but some people, their houses are 50 feet apart or something, and or closer. Sometimes we're down to 10-foot setbacks here, so you might have people coming right in next door to you. As should die.
Well, I think that the point, it goes back to this land use thing. I'm against this, only because of the way, I think it paints with way too broad of a brush. I think this works in some areas it doesn't. And it's specifically in a subdivision. When you move into a subdivision, it's single-family residences. Now that we had a thing up there from the Board of Education, they had a subdivision up there, Locust Grove something, 120 lots. Well, now that sign should say 120 lots or business opportunities. Because now you can take your house, and it's strange that we brought up, I've heard ADU mentioned twice, how the people can now move into the ADU and rent out their front house. That's exactly why I was against the ADUs. It's just it's just more densification of our neighborhoods. It's more of disrupting the quality of life in our neighborhoods and our subdivisions. To me, and this you've mentioned, and you mentioned, it's bringing on more work for our law enforcement. It used to be, well, they'd say, and by the way, don't use Bob's stuff all the time, okay? Start using it different. Bob's not running a truck stop or a flop house, okay? But if they go to my house, the 10502 Mountain Ash Lane, they'll say, well, that's Glen Oaks, where they know. Well, that's a residential subdivision. Well, they might roll up on it, and it might be, and I'm not knocking anybody, they might be roll up there, and there's 4 cars from California out there having a big time. And well, the neighbors going to say, they're going, well, what are they doing? I mean, these people just move in here and move out of here, and I understand you get all these words, and y'all have done great work, and I mean, this works someplace. But it don't work in residential subdivision, because most CCRs that I've read says single-family residence, not single-family residence, or if you want to rent this out, you can do this. So I can't vote for this because it's not definitive enough. I'm not against it, it's just not defined.
Ask Mr. Urban to clarify if we're giving permission here to something that doesn't happen now, and we're codifying, or are we codifying something that does happen that's not illegal at this point?
Right.
Voting for this doesn't stop it from happening. It's already happening.
We already know it's happening.
Right. I think what this ordinance does is try to put it on a playing field that is equal across the county, and add some degree of regularity to it.
That's exactly what I was going to say. 2 points. One is related to the CCRs. We put in there, you have to show us that you comply with the CCRs and it's allowable. And if it's not, you can't do it. But like the judge just said, this is already going on, and we have no way of regulating it. What would be, when we get a complaint other than maybe noise and the police that's already going out there, like Mr. Eldridge said, what do we say to them? You know, they're renting it out and we have no standards.
Can I ask a question, Judge?
Sir.
Do we have to vote to accept this? In other words, do we have to allow short-term rental in our subdivisions? Or do we, are we say that
This is not
we're?
voting to allow short-term rental.
This is the umbrella. This is
This
not,
is,
this is the umbrella of the situation that we have at hand. You're not voting to have an individual neighborhood. They still can have their restrictions, deed restrictions, HOA restrictions, a whole host of other things. But this is more of an umbrella, not the granting the permission.
right, this is not promoting
Right.
the short-term rental. This is developing standards for people that are either doing it already or wanting to do it. It's not promoting it necessarily. That's the big distinction here.
I think we're mixing
So-
what the purposes of
Right.
of this.
So if you chose not to approve it, then it could happen willy-nilly.
But,
Willy-nilly. It's getting late.
but do we have to allow it to happen willingly? Are you saying that if everybody's out here, we had the drug issue earlier today, if everybody's out here smoking drugs, does that mean we just give up and say we're all going to be smoking marijuana? Or do you say, wait a second, we're not going to allow this in our subdivisions. If you're not in a subdivision, you're out on a single lot, you can do that with your property. But if you're in Heather Hill, then I'm not sure I want 20 teenagers there this weekend for Derby weekend, because I'm not sure I just want that.
So either an existing CCR has that restriction, or the homeowners association can put it in their restrictions that they don't allow short-term rentals. That would support not issuing permits through this process. But in the case where there's either no deed restrictions or no HOA enforcing it, you know, it could be happening and there's no way to control it. We can't say you can't do it. How do we go enforce it once we find out? We say, you can't enforce it.
You could
can't do this,
find
land
the
use.
property owner that's doing it.
For what now?
And I'm not saying this is what you do. I'm just getting to an issue that I think we need to think about.
I agree, but I think that this is the umbrella to drill down to this part that you're talking about is probably something else that needs to be addressed at a later date. But without this piece, I don't see how you can regulate what it is that you're talking about and what Bob's talking about.
Right now, unless there's some homeowner's restriction in Heather Hill, your next door neighbor can do exactly what you're saying you don't like. This is not giving them permission to do it. They already have the ability because we have no restriction on it in the county. What this is doing is trying to round up the loose pieces and put them in some kind of order here and manage it.
Kevin's got something.
Kevin?
Well, to echo that, in other words, if you had this ordinance and you had those 25 kids, then they could be ticketed because it says plainly how many people can be there. As it is right now, they can go over there and say, you all quiet down, but they haven't done anything wrong because there's no ordinance, there's no organization at all. We've heard testimony that there's 200 to 300 listed on Airbnb, but they're probably not all in the county. You've got 200 or 300 of these already going on, and we don't know how many are in your neighborhood. They haven't bothered you yet. But if they started to bother you, you wouldn't have any way to slow them down because you don't have an ordinance. You don't have any permitting process.
A couple of years ago, we had a case on the north side of the county where there was a big house with a pool, a hot tub, and the people didn't even live in this region, and they were renting it out on a regular basis. And they kept calling and saying, how come, why don't you stop them? We were able to take them to the code enforcement board and finally got them to stop doing it. But we didn't have any real regulations to say, you know, that you can't rent your house out. Renting houses out falls under the Fair Housing Act, and that has been tested in courts, that we cannot regulate who lives in a house. but we can regulate short-term rentals because, again, it's a business land use.
Mr. Leslie?
Call for the question.
All right, we had the motion here. Is there a motion that we adopt this short-term rental policy as part of the land use revisions?
I'll throw that up on the wall.
Second.
All right, moved and seconded that we do so. And we've got a call for the question here, so all in favor, please say aye.
Aye.
Opposed?
No?
Motion carries.
Tell me who though?
Magistrate Dye and Magistrate Tice.
Tice and Likens.
All right. Motion carries 6-3. Right, do we have another item here?
Just one last short one, and that is that we looked at the maximum height regulations.
You're going to get your some of our people are going to get their second wind here. They've been waiting since 2 o'clock, and it's only 5:45. So. Go ahead.
Okay, I just said there was one more, there are two more, maximum height regulations. In particular, what we're recommending is that in the C2, C3, and C4 business district, that we increase the maximum height allowable from 45 feet to 60 feet, which is a 15 feet increase. We had a particular case where a 4-story hotel was proposed, and the parapet wall was at about 48 feet or thereabouts, so they had to get a variance. We don't believe that increasing the height to 60 feet is going to create skyscrapers necessarily, but with the current construction techniques, parts of buildings might be at 60 feet. Again, this is only an increase in the C2, C3, and C4 zoning classification.
Is this Article 3?
No.
No,
Subdivision consideration process?
one right here.
no, this is, I have one more
I have
before
that.
Article 3. Right.
Is this one sheet
Should
here?
be just one sheet, right.
All right. Is there anybody to speak for or against this? Is there a motion accepted?
I'll make the motion.
Second.
Discussion? All in favor, please say aye.
Aye.
Opposed? Okay, got that one down.
Judge, I'd like to bring up a point of order.
Okay,
Back to call for the question, I wasn't sure, so I looked at my Robert's Rules of Orders. To have a call for the question requires a 2/3 majority. So with the vote that we took on the STRs would not be valid. We'd have to go back to that point, wouldn't we?
Call for the
in other words, we didn't take a vote on the call for the question?
Yes, sir. Did not. It takes 2/3 to stop this
All right, we'll just, let's just unwind it here. Correct, Mr. Carter? Go back and call for the, I'll go back and take a vote on the call for the question.
Well, let me get my microphone working. When a question is called for, the moderator has to ask if there's any further discussion. If there's no further discussion, you vote on the question. You vote on what's before the court. If somebody wants to say something further, then you have to have 2/3 majority to call the question.
I thought call for the question shuts off debate
Unless it fails.
unless it fails. Or no, he's saying that if anybody wants to continue discussing it, we have to have 2/3 to not discuss it.
To cut off debate.
Right.
If somebody
All
wants to
right,
keep
so I'll back up and say that Magistrate Leslie called for the question. Is there anybody that wants to continue discussing it? No, I see no, so we're back to the vote. All in favor, please say aye.
Aye.
Opposed?
No.
Opposed.
Motion passes 6-3.
Thank you.
You have to vote to stop discussion. Correct. So you have to have 6 out of the 9 to stop discussion, and then if that is successful, then you have to take the vote.
Right, we've got the difference of opinion here on this. We'll do it both ways, and then we'll get it right. And pity our clerk who can explain this, but we'll short circuit it in the minutes. All right, Magistrate Leslie's called for the question. All in favor of shutting off debate, please say aye.
Aye.
Opposed? Debate is shut off. Now we'll take the vote. All in favor of accepting that article, say yes.
Yes.
Opposed? Okay, motion passes 6-3. All right, you okay
No,
with
it's
this?
not all right. I'm just saying that we got to do it right.
Okay, now we're on to,
Yes.
this is the last one.
This is our last topic. Article 3, subdivision consideration process. This is not part of the Oldham County Comprehensive Zoning Ordinance. This is part of the Oldham County subdivision regulations. The first paragraph is mainly just grammatical, to fix the structure of that sentence and paragraph. And then the other is just adding, under divisions and applicable information, just easement plats. We added that information in there and included steps 1 and 6. The next item is, get to my schedule here. We just relocated the paragraph here that is in green. That was after where it talks about approval of final plats. That talks about when a subdivision plan has not gone to construction plan approval. They have 2 years to do that from the time that the Planning Commission approves that. If they want to, they can ask for extensions at in intervals of 1 year. Then the last paragraph there says, all approved final plats shall be recorded within 1 year. It previously said 6 months. All of the stamps that we have used in the past, since I've been back with planning and zoning for the past 7 years, has said 1 year, not 6 months, and even previous stamps have had said the same thing. So we're just clarifying that what we have procedurally been doing, not 6 months, 1 year. Postponement, the commission or its designee may postpone its decision pending further study of the plat. There was additional language in there that talked about the 90-day restriction. That is regulated through KRS 100, and we found it redundant, so we removed that part of it there. Amendment and revocation of a plat. That basically says that if the administrator is not comfortable with approving a plat, it can be referred to the commission. So that's just adding that language in there that says that any plat that doesn't require a variance or a waiver that can be approved administratively can be referred to the commission by the administrator for approval. This section here talks about the steps for a subdivision consideration process. Previously, all neighborhood meetings were only required for properties that were requiring a zoning map change. We have added in here that is for all subdivision plans, regardless if it includes a zoning map amendment or not. So any subdivision, even if we ask that that they all have a neighborhood meeting, and then we also ask clarification or added clarification in there what the definition of second tier is. Which says that are within 500 feet are to be notified only if the plan is part of a zoning map amendment. So if it is a subdivision plan, regardless if it's a zoning change or not, they are required to have neighborhood meetings, and only if it is a subdivision, a zoning map amendment for a subdivision, they are required to notify second tier property owners as well. This again talks about the Planning Commission preliminary plat process that says any major preliminary plat, so any major preliminary plat, which means creation of 4 or more lots, is required to have Planning Commission approval through a public hearing process. And then the last sentence says any minor plat complying with the substantive requirements of these regulations as determined by the commission staff should not require the holding of a public hearing. So any minor plat that comes in with a property line shift, consolidation, or anything that does not require any variances or waivers can be approved by staff, which is the process that it is now. Construction plans, this was reviewed with the county engineer, and I got the wording from him on this. It says, upon approval of preliminary plat and prior to construction of any physical improvements of the subject property, a subdivider must submit a soil and erosion control plan simultaneously with construction plans as required by local, state, and federal agencies, providing technical data concerning the location, type, and quantity of specified Physical improvements and/or infrastructure. Construction plans are to be reviewed and approved by the county engineer. The soil and erosion control plan must be in place before any earthwork may begin and shall comply with all Oldham County ordinances. And again, that was reviewed and approved with the county engineer. This is the whole reason that this part was looked at, because the part that is that has been struck from this step number 5 defeats the purpose of capacity planning. The part that was deleted says if the final plat or record plat conforming to the approved preliminary plat is not submitted for review and approval, whether in total or in phases within 3 years of the approval date of the preliminary plat, then the preliminary plat is considered void and the plat must again be submitted as a preliminary plat. So this is basically saying at the time that the planning commission approves it, they have 3 years, that 199 lot subdivision, they have 3 years to get all of that to record. Well, if we have a phasing plan, which we've had in place, even when it was 40 lots per year, there's no way that it would ever go to final record plat within those 3 years. So we struck that out from the step number 5 because that obviously defeats the purpose of capacity planning. And then finally in step 6, that just again changes that any plat is to be recorded within 1 year of receiving all necessary approvals rather than 6 months, because that has been the practice. That is all I have on that.
Anybody here who wishes to speak to this subdivision consideration process? I'm going to assume no, and see no one standing, so we'll close that part of the hearing. Is there a motion to accept these changes?
Second.
Moved and seconded, discussion? All right, Magistrate Eldridge?
Just glad to see those one-year extensions be stricken. Glad to see that go away. Thank you.
It doesn't go away. It said, that was on the recording of the plats.
The area stricken says when requested, one-year extensions of approval may be granted.
That's not, it's in green. That was just because it was moved, it was
Right.
relocated.
Right.
It does not have strike through it. See, it's not stricken
That
through
came
like in
from
the
a
red.
different part of the regulation.
Do we have any ceiling on those?
We do through administratively through our extension of expiration policy. I believe that they can ask for four extensions. So that basically gives them 6 years from the time of approval. And if they've not moved forward from that, then they have to come back to the planning commission. That can only be reviewed at stat. And the process for extension of expiration is that they apply. I send the request out to all the utility agencies. They reply back via email that they can still serve that development. If one of them comes back and says, no, we no longer have school capacity or we don't have sewer capacity or something of that nature, then at that point they're required to come back to the planning commission for full review. But they can only get 4 extensions at this point.
Okay, thank you.
Did we have a motion? All right, any other questions? Motion and second on this. All in favor, please say aye. Aye. Opposed? Okay. So moved.
Great. So Judge, the last thing you have to consider is the actual ordinance itself. It's KOC 18-920-447. And this spells out the affected sections. It's a little more extensive, but because we're changing various parts of the regulation, you'll see that all the sections are shown on this that allows us to go ahead and effectively change everything you've just adopted, plus just the changes that we just made. So you have to consider adopting this ordinance.
All right, is there a motion that we adopt ordinance number KOC 18-920-447, repealing and replacing certain sections of the existing Oldham County Comprehensive Zoning Ordinance?
So moved.
Second?
Second. Any discussion on this? Hearing none, all in favor, please say aye.
Aye.
Opposed? No. Motion carries 7-1. Thank you.
Thank you all.
All right. Pardon?
8-1.
8-1, yes. Sorry. All right, now we're going to go to, believe it or not, the first reading of the proposed updated smoking ordinance. And I apologize to the people from the Health Department who have been here for hours waiting for this particular item to come up on the agenda. And so That is item D in your book here. So we have an ordinance repealing and replacing ordinance 06820-464 relating to the prohibition of smoking in Oldham County, establishing a new ordinance. The new ordinance is to protect public health and welfare by prohibiting smoking in public places and places of employment. Our additional circumstance here is that, whereas high-tech smoking devices commonly referred to as electronic cigarettes or e-cigarettes that closely resemble and purposely mimic the act of smoking, having users inhale vaporized liquid nicotine created by heat through an electronic ignition system, have been proven to contain numerous risks to human health. After testing a number of electronic cigarettes from 2 leading manufacturers, the Food and Drug Administration determined that various samples tested contained not only nicotine, but also detectable levels of known carcinogens and toxic chemicals, including tobacco-specific nitrosamines, and some glycol, a toxic chemical used in antifreeze. The FDA also suggested that the quality control process used to manufacture these processes are inconsistent, or products are inconsistent and non-existent. So we're adding electronic cigarettes for this and a few other reasons, along with anything else that you can smoke or inhale. Now, Liz, would you like to come forward and perhaps summarize for the public? I think that's our main change here in the smoking ordinance. Am I correct?
It is. It is the main change, and thank you guys very much for letting me come back up here and talk. We passed the current ordinance that we're under now, we passed in 2006. So it's about 10, 11 years later, and electronic cigarettes weren't available really even until 2007, 2009 in the United States. So we wanted to revisit the ordinance, make it a little bit stronger, include electronic cigarettes because we know that they're also contaminating the air. So we wanted to make sure that we're protecting our employees and our visitors to Oldham County. The other thing that the revisit did to the ordinance was to remove the exemption. When we passed it in 2006, there was an exemption added for smoking break rooms. And we know based on science that those break rooms are not effective in eliminating exposure to secondhand smoke. So while we were revisiting it with electronic cigarettes, it just seemed like a good time to remove that exemption as well.
Right, I want to read, I think the key point we want to make here on this first reading, and there will be another reading in, I guess, 30 days here, or second meeting of the next month. Smoking, the definition of smoking, the use of any device used to ignite or heat tobacco or any other substance, whether natural or synthetic, for the purpose of inhalation, exhalation, burning, or carrying any lighted or heated cigar pipe, hookahs, or any other lighted or heated product intended for inhalation in any manner or form. Smoking also includes the use of an electronic smoking device, which creates an aerosol, smoke, or vapor in any manner or form, or the use of any oral smoking device for the purpose of circumventing the prohibition of smoking in this article. So this doesn't affect you in your home or in your car or outside, but it does affect you inside and at your place of work, and it's intended to prohibit the use of electronic tobacco in Oldham County, or hookahs,
Or hookahs. Yep.
correct? Or anything like that.
That is correct. And there are new devices coming on the market pretty consistently.
Anybody have any questions for Liz? Magistrate Leslie?
I don't have a question. It's a statement, and it has to do with the definition of smoking. The current policy states specific items. So the ordinance is exclusionary to those items, and I wanted that changed. And that's why I put the IE in there. So these are examples of things that are currently being used. And since it is an example, that means, as Liz said, additional things that come onto the market will now be included in the ordinance, does not have to be changed.
Okay, and I know there's something now you can plug into your computer or something like that, and, you know, it's just, our imagination can't keep up with the imagination of some people, I guess.
Yes.
Of what's next, you know? So, all right.
Any other questions? or-
Okay, no, I don't have any other questions about it. Does anyone have any?
Thank you all very much.
All right, thank you. Next, that's just the first reading, so we'll let it. Next item has to do with our payables under County Administration A. If you, pardon?
No, that's later.
We have to go
Skip
back.
payables.
We jumped ahead to get to that because Mr. Williams had to leave at 4:30 or so.
I move that we pay the payables.
Second.
Second.
Motion to pay the bills. Is there any discussion on it? Hearing none, all in favor, please say aye.
Aye.
Opposed? All right, item B, surplus property. Ms. Horn?
Asking you today to surplus, to salvage a 2014 Ford Police Interceptor Utility, which is also known as an Explorer. This vehicle hydroplaned on I-71 near mile marker 16 and went into the cable barrier. There's extensive damage to the driver's side. Our claims adjuster determined that it was a total loss. So we will receive $11,725 for this vehicle, and then Copart Auto Auction will take it for salvage.
So moved.
Second?
Any discussion on surplusing this vehicle?
Just one question, the officer was not harmed?
He was not, correct.
I got a question, Melissa. Do we strip out the electronics on these, or do they take
Yes,
the
we
car in
do.
whole?
No, we strip out anything that we can use again.
Okay,
Yes.
thank you. And do they take the decals off of it?
They
like we-
do not take the decals off when it's going to salvage.
One side.
All right, thank you.
The one side that's good, they're gonna take that off.
All right, hearing no further questions, all in favor, please say aye.
Aye.
Opposed, so moved. Next item has to do, I ask Jerry Nart to give us an update on our flood management program and also Becky Zockline. You're an hour and a half into overtime here, so.
Then I'll say good evening, Judge and members of the
Okay, right,
court,
okay.
Madam Clerk and Mr. Carter. We'll try to be brief as we can. Flood operations, having been involved in several on the Mississippi in my past and stuff, this one with some very able people that we have here in Oldham County it went and is going very well. We had no reportable, if you will, public infrastructure damage, which means we won't get to that $221,000 that FEMA will require for us to be able to claim. We do have expenses, but they're not going to get to that way, and Ms. Zockline will give you some of those. I'd like to give you just a couple of things that did happen, though. We mentioned the Oldham County police officer who hydroplaned responding to a wreck on the opposite side, but he came up on the water, and you asked if he was hurt. Well, my son happened to be the first one on the scene and opened the door, and he said his eyes were pretty big, but he wasn't hurt. But he hit the water and was relatively okay. North Oldham Fire Department, very humbled. The chief, when I called because I'd heard that they, quote, had done some rescues, and I guess he's like me and the Coast Guard. Rescues means somebody jumped out of a helicopter or off the side of a boat in hurricane waters, but he said, no, we didn't do rescues. He said, we got a couple people out of the house that needed medical attention by boat and got them to the ambulance and then on. And then one other person, a lady who was wanting to try to wait it out, but when the power was cut off, she elected to leave too, so they helped her out by water. But he said he didn't claim them as rescues, so that being very humble. And then Westport rescued some propane tanks that were floating down the way, if you want to call that rescue as well. Oldham County police officer, not the one that was injured, but another one actually waded through water, high water, damaged some uniform parts and such, but in order to get some people out of a vehicle. So he was very courageous in doing that. But as far as overall damage, FEMA is now just arriving on the scene. I talked to the Area 4 Kentucky Emergency Management Director, who's my next level up on the state. In fact, he called while I was sitting in the meeting with some information that I haven't heard, haven't played the voicemail back yet, but to determine at what level and what we can do for the individual assistance requested. Formally, we have only had 5 people make a request to be considered for some individual assistance through FEMA. There are, and Mr. Urban will probably tell you how many homes that his crews have been into, but we've only had 5 come through my office, and so we're going to see how we can deal with those. I'll turn it over to them for further information. Mr. Williams was here, and his crew, when the times I was down there, they were down there working diligently, scraping mud. They need to be commended for that. I saw him bug out, and it's probably for the fact that frozen white precipitation is beginning to fall, and he's probably looking at that. The only other thing I'll do, I'll digress for just a minute, because last meeting I think there was a question about Oldham County's emergency operation plan. Did we have one? What it was? The judge answered it correctly. It is maintained and maintained on the website, meaning that we maintain this periodically and that it is posted and maintained on the website as well if you need it. Barring any further questions of me, I'll turn it over to my colleagues here.
Anybody have any questions for Jerry? All right, thank you, Jerry. Appreciate it.
For residents that's, you're starting to get the floods and you start to panic, who do they call and how does that take place?
If it's that much of a panic, 911.
911?
Yeah, and we'll get whoever needs to be there to them.
Got it. Thank you very much. Thanks you for all the work you did.
All right, thank you. Appreciate it. Becky?
As of yesterday, there were 22 dumpster loads that were pulled from the Riverside communities, and they're listed here. Westport had 3, Tartan's Landing had 1, Riverside Drive and Huckleberry Lane had 16, and Cardinal Harbor had 2. 1 dumpster is still at Cardinal Harbor and will be pulled tomorrow. The total tonnage that I estimated, based on the cubic yards of the dumpsters, was 924 tons. The estimated cost as of yesterday that I was given by Republic for just the dumpsters and disposal was under $5,800. There will probably be more costs onto that with the Cardinal Harbor dumpster, but I don't have a final bill yet.
If I might interject as well, I'm sorry, Rebecca.
Yeah.
Mr. Urban and I both have received additional requests for dumpsters down on Lakeside.
I was just gonna get to that. Okay, hang on. Okay.
My apologies.
All right. In order to save costs, our road department sent their dump trucks down to Riverside Drive and to Westport, and they hauled away 22 truckloads of debris, a total tonnage of approximately 265 tons of debris. We had 5 tons of woody waste that was taken to the reformatory that will eventually be burned, and the rest of those truckloads went to the landfill. And as Jerry pointed out, we still have debris on Riverside Drive. Our residents down there lost their trash cans. We have a lot of trash cans in the Ohio River, maybe down in New Orleans. But at any rate, they have no means of getting rid of their trash as they're expected to. In fact, I had a complaint this morning, because today is their trash day. This morning was their trash day. There was a mound of trash piled beside somebody's regular trash carts that the driver stopped and had to load. He emptied the cans and then loaded those cans twice and there was still debris on the ground. So the residents down there are in a bad way. I know Republic is working hard to make sure their cans get replaced, but we don't think about that. They lost their trash cans in the flood. That's not the first thing they're going to save. So that's part of the difficulty of when you have a disaster. So at any rate, we do have additional household debris, construction debris down on Riverside Drive, and debris we hadn't counted on that's not directly flood related down there. And there are people still in need for removing that debris. The other information that I got from the road department is that they use 94 gallons of fuel for trucks and 115 gallons of fuel for their equipment. They had a backhoe and a skid steer on Riverside Drive and in Westport going around picking up piles of debris like refrigerators and appliances that were filled with mud that had been placed at the roadside and putting them in the dumpster.
All right, Becky, anyone have any questions or anything on our response there? It's an unfortunate circumstance, and we've tried to do the best we can to help out. Okay, thank you all very much. Did you want to say something about that?
I was asked to also present information about the flood. As some of you know, I have one of my responsibilities in the county is floodplain coordinator. There are two areas I'd like to report on this evening. One is about our building and electrical inspections and the flood recovery, and then the substantial damage assessment that I'm required to do as the floodplain coordinator. So in terms of building and electrical inspections, after the flood, our first priority was restoring power. There were 429 meters that were shut off by LG&E. Those included single-family residential, garages and accessory uses, and even boat slips. Approximately 325 of those were houses. And not all of them were directly affected by the flood, but power, as an example, was shut off to Hidden Valley because LG&E couldn't get down to Hidden Valley if, in fact, it started to flood. None of the houses were actually flooded, but when it came time to restore the power, we still had to go down, review everybody, make sure that they weren't affected, and get them turned back on. So our primary focus was in residences, the primary residences, and quickly we were in Cardinal Harbor, down in Westport, a few in Belknap Beach, and power got restored as the water receded. Then Tartan's Landing, and then the two neighborhoods on Riverside Drive, both Harmony Village and Oldham Acres. It was great that LG&E had assigned, actually in the beginning, 2 line crews, but ultimately 1 to work with us directly. And both Scott Thompson and Jerry Dunaway were in close communication with them, doing inspections, making sure that electrical contractors were employed whenever that was necessary, and then getting the power back on. So at this point, we have about 195, between 175 and 200 houses now have restored power. And we're starting to get calls on secondary houses, people who have either summer houses or they were out of the area during the flood, and now they're starting to come and call us to do inspections and restore power. The second responsibility is substantial damage assessment, and I'm supposed to perform and document damage to all structures. So what we did was we created a spreadsheet that Amy was able to put together for us, and it pulled in information from property valuation and all the information regarding home ownership and mailing addresses. When our electrical inspectors were going down and doing the electrical inspections, Darrell Townsend, our code enforcement officer, went with them. He documented all of the flood damage in all the properties that we went into by photographing it. We've then categorized it according to FEMA's requirements for either, I've added no impact, because there were some houses like Hidden Valley had no impact, minimal impact, substantial, and then heavily damaged. And it is up to us now to collect information from either insurance claims, contractors' estimates, or by doing our own estimates to determine the damage on each of the properties. And we're working with property owners to recover either from insurance or also, as you know, you've been endorsing us to, since 2014, to apply for FEMA grants to either acquire properties or elevate structures. At this time, I want to make sure and compliment Jerry Dunaway and Scott Thompson, our electrical inspectors. They always go above and beyond to service everybody in the county, and especially not only doing the regular inspections on new construction that we were doing, but for the flood damage. Mark Tice, our chief building inspector, we're working with him to go look at properties to make sure there was no structural damage before they start repairs. Megan Cray, our permit clerk, worked overtime. She even had her children in here on a Saturday so she could keep up with all the permitting, all the calls we were getting. And then Daryl Townsend, our code enforcement officer, like I said, he went out with the electrical inspectors. Amy Alvey, Matt Toller, and Jeff Rice. Jeff is in maintenance, but he hurt his knees, working with us to coordinate all this information collection. And I think that's part of what FEMA is going to require from us. So we'll have this spreadsheet available. It's not going to be complete now that they're here, but we're starting to gather this information. So, Judge, unless anybody has any questions, that's my report.
Thank you, Jim.
Judge, I'd like to thank Jim and Becky and everybody for all the extra work that they did. This is in addition to their normal work activities. So thank you.
Right, you're absolutely right. The problem comes along, we have to expand to absorb the extra work. All right, thank you very much. The next item here, I believe Magistrate Leslie had something about fireworks he wanted to bring up.
Yes, I do. Judge, it's that time of year again when we need to do a contract for the 4th of July fireworks. We're going to use Casabella Pyrotechnics again, and the cost is the same as it has been in the previous years, which is $15,000. We have a rain date of July 5th if they can't shoot them off the 4th. And before June 15th, we pay $7,500 so they can buy the fireworks. And then on the 4th of July, we pay them $7,500 to shoot them off. So it's the same as we've been doing for years. And I'm making a motion that we give you permission to sign this.
A second, Judge.
Moved and seconded that I be allowed to sign an agreement for a fireworks display for the 4th of July at the Wendell Moore Park. Discussion on that?
I have one comment. I mentioned this in our Parks and Recreation. I'd like to see Tim Curtis make an all-day event out of this, maybe at the park, kind of like they do at Thunder over Louisville. This is a great fireworks show, a great one,
Right.
if you've ever been to see it. But I think we maybe ought to expand our just the fireworks show. People show up at dark, and then as soon as it's over, they leave. But I'd like to see some kind of all-day event.
Okay. Well, we'll
maybe
discuss
we
that
looked
with
at.
Tim, and I do think we do have people out there picnicking and things like that.
All kinds of contests and
And
swimming.
the swimming, the pool is open, so there are,
Live
let's
entertainment?
find out, yeah.
Oh, that's going to be called Thunder over Buckner? Is that what you're looking
May
at?
have more out there than what you realize, yeah. But there's a huge throng for the fireworks. So, any further discussion on that? All in favor, please say aye.
Aye.
Opposed?
Yes.
Motion carries 8-1. Next item is personnel actions. Ms. Schaaf is moving close to 2 hours overtime today. Okay.
I am. All right, for personnel actions, we have two recommendations. Parks and Rec, we have a new hire, Amanda Leach. She's the community center assistant at $11.96 per hour, effective tomorrow.
So moved.
New hire, Amanda Leach, effective tomorrow at 11:96. All in favor, please say aye.
Aye.
Opposed? So moved. Next.
And we have a status change for animal control. Suzanne Schulte, we're making her a full-time employee, animal control officer, effective April 1st.
So moved.
All in favor, please say aye.
Aye.
Opposed? So moved. Thank you. All right, and then you have another item here to discuss, and that's the retirement system.
We do. Handed out before the meeting a recommended order from, a recommended order from the Kentucky Retirement System. They are asking the county to pay actuarial cost for spiking. They invoiced us for spiking on an employee that retired in July or August of 2015. So when someone retires, there's the spiking law that went into effect in 2013. So basically it was put into effect so we don't have a lot of overtime just before someone retires, so it bumps up their retirement. So the only reason someone can have an increase of more than 10% to their salary in the last five years is a bona fide career advancement. So we had an employee that retired August 1st, and in that year there were 3 pay periods in July. So that was the beginning of a fiscal year. So in July, that person made one more paycheck. So they took the 3 paychecks and projected it out over what they would have made. They figured out what he would have made. So they said that this employee got a 12.73% increase in compensation. So we had an administrative hearing on it, and we were, John Carter, we were going to go ahead and just pay the $425 because it was a lot of effort that we were putting in. And but then we got the agreed order, and Mr. Carter doesn't like the wording in it, and he's going to talk to you about that.
All right, John?
Well, as I understand it, we got a bill for the $420 from the retirement, from the Kentucky retirement system, and Tina appealed that, so they set it for a hearing. And I suggested for $425, she and I didn't need to go to Frankfurt and spend a couple hours or more. And so we thought that maybe the fiscal court would want to go ahead and pay it, but we get this agreed order in which they require us to admit that we engaged in spiking. They don't care that it was just the fact that he got paid 3 payments in 1 month. They're going to call it spiking, and they're claiming that that's creditable income under their definition. So, I mean, I'll leave it up to you all. For us to proceed, it would be a hearing in Frankfurt in front of a hearing officer, and if we lost there, we could appeal to the pension system. And then if they affirm the hearing officer, we would have to appeal to the Franklin Circuit Court from that decision. So although it's administrative, it does get into the court system eventually if you're going to contest it all the way. What I would like to do is tell them we're not going to sign this and agree that we engaged in spiking, but we will, if they send us a bill, agree to dismiss our appeal upon the payment of $425, but we're not admitting anything.
Well, the fact of the matter is that we have not done anything inappropriate.
But they claim, I've
An
talked
odd
to
circumstance with 3 pay periods in 1 month. They projected out over 12 months, even though he only worked 1 month in the
Tina
fiscal
and I
year.
talked to the person that calculated it, and they're adamant that even though it's just as a result of 3 pay payments in 1 month, that it's still spiking.
And the reason they say it's spiking is because those situations are not addressed in the bill, in the law.
But first of
Doesn't
all,
matter.
I've got questions here. First of all, we just got this before court, so none of us read it. Second of all, how come we're not in closed session talking about litigation?
This is not a closed session item.
Well,
It's a public item. There's under what statute would you go into closed session on
I
this
think
for?
it's litigation. I mean, we're talking about something
We're
being
not
sued.
talking about litigation. We're talking about administrative
Okay.
letter. This
Well,
is
I'm not ready to vote on. We just got.
We have a deadline, and we just got it too, so it's not, I don't know if we can, that's the only reason that it happened today. It's because there's a
We're
deadline.
going to argue
for a
all
claim.
day for $425.
If we owe it, let's pay it, but if we didn't do something wrong, let's get the record straight.
It's going to cost us a lot more than $425 to straighten the record out.
Well,
unless they bend.
then I like John's idea, just a bit to nothing.
I think John suggests that we just send them a check and don't sign it, correct?
Well, I'll have to call this lady and tell her that I've discussed this with fiscal court, and you're not willing to admit that we engaged in spiking, but we'll dismiss the appeal and pay the $425 without any admission because we didn't do this.
Is that like an Alfred plea?
It's not a criminal proceeding,
Isn't it just a
please.
mathematical formulation that's got this screwed up?
It sounds like football.
The thing is, it's not
15-yard
addressed in the bill,
penalty,
so if it's not a career advancement, they don't care what it is.
Okay,
That's the thing.
okay.
It could be anything from leave without pay, and then the person comes back, you're still gonna get a spiking invoice.
Judge,
Magistrate Eldridge.
I'd like to make a motion that we allow Mr. Carter to contact these people, telling them that we do not feel that we are in any way negligent or guilty, but we are willing to settle this at $420 and clean the matter up.
Second.
Further discussion? All in favor, please say aye.
Aye.
Opposed?
Aye.
Motion carries 7-2. Okay. I think we've reached the end of today's meeting.
Judge, are we gonna look at these
Pardon?
bids for the roads? Have they been
All
coming
right,
back
do
in?
we have those bids? Have they come back in?
Judge, Louisville Paving Company was the low bidder in all three situations. And I would make a motion that we accept those bids. Those bids also included Crestwood and Pee Wee Valley. Can we accept for them?
It's a group.
I don't think we can. I think their city council has to. So I'm going to make a motion that we accept that portion of the bid that pertains to us.
I'll second.
And the amount is $497,289.67. The three total together.
I think you need to accept
Individual.
package 1, package 2, and package 3,
Okay.
okay?
I'll make a motion that we accept package one.
Well, or,
Package 1.
One,
Crystal Lake.
Crystal Lake. And we're going to do 1, 2, and 3.
Okay.
And-
All right,
Amount.
motion made to accept package 1 for Crystal Lake.
In the amount of 315, 110.
Chris Hound seconded it.
All right, all in favor, please say aye.
you're awarding it to Louisville Paving.
Yes.
Awarding it to Louisville Paving, all right? Okay, you've got another one?
I'll make a motion that we accept Louisville Paving for the Group 2, Walnut
Road.
Road Group.
Second.
Moved and seconded, we accept the Louisville Paving bid for Walnut Road.
At what price?
144, 144, 79.
It is 144, 144.
44, what?
$144,144.79.
All right. For the Louisville Paving price, all right. I don't have to repeat that. All in favor, please say aye.
Aye.
All right, third bid.
Third group is Old Floydsburg Road, Louisville Paving, once again, at $252,205.63, if I wrote it down right. And I would make that motion.
Second.
Point of order.
Sir?
Mr. Greenwell, did we need that language in there you were talking about where you're accepting only the Pee Wee and not accepting the Pee Wee and Crestwood?
Yes. In other words, it's just the portion that pertains to Oldham County.
Which is $38,033.98. And that's Group 3. It's the only one.
All right, motion made and second, we accept Group 3 paving minus Crestwood and Pee Wee Valley for whatever the stated amount was. Minus 33,000.
Our amount is $38,033.98.
Okay, 33,000.
Which,
Right.
which means that up on the second, that's correct. No, I'm sorry. 38,000.
252, mark it out.
Yes.
And it's
Yes.
33,000.
38.
38,033.98.
Also,
It's late.
Melissa,
Yes.
up on the second one, I said 144, 144. That was for the whole thing. So what's,
Second one is all Oldham County.
Okay.
The only one that has other
Floydsburg.
is the Floydsburg Group.
Okay, thank you
Yes.
for that clarification.
Okay, all in favor, please say aye.
Aye.
Opposed? So moved. All right.
Thank you, Sheila.
Okay, now we're down to the last final comments here, and we're going to make them pretty quick because, believe it or not, I think most of the fiscal court members plan to attend the dinner at 6:30 at the community center. And maybe it started at 6, I'm not sure.
Started at 5:30.
Started at 5:30, okay, well, I knew we were going there after.
The dinner starts at 6:30 according to the invite.
Magistrate Logston. Magistrate Dye.
Nothing.
Magistrate Eldridge.
Nothing, sir.
Magistrate Downs.
Nothing, sir.
Magistrate Greenwell.
I would urge everyone to be careful because it is snowing like crazy outside, and watch out for the road department.
Magistrate Leslie.
Nothing.
Magistrate Tice.
I just want to say that I hope Brooke and the new baby are doing well, and just want to say that.
Magistrate Likens.
Just want to wish everybody a happy first day of spring since it is snowing outside. So.
Okay, I guess we're more or less, I won't say punch drunk, but we're ready to have this meeting come to a conclusion. It's been one of our longest meetings in a while, quite a while, 4.5 hours. So thank you all. If anybody watched this for 4.5 hours, we'll give you a medal. We don't get one for sitting here, but we've been here. So anyway, thank you. Is there a motion to adjourn?
So moved.
Second.
All in favor, please say aye.
Aye.